Thanks, Johnny. Well, I hope you find this session interesting and valuable. I can suggest to you that had we put a question on your registration for part of your qualifications for attending today is, do you know how initiatives get on the ballot as ballot initiatives? I think we would have a profoundly surprising outcome of people saying, I thought I understood it. I guess after learning about it, I didn't, and I wonder if that's the right way to continue to do it. The good thing about the West Michigan Policy Forum is that we suggest, we inform, we enlighten, and we have conversations. And that is why you're here, and that's what you're going to get out of this group too. We don't put firm recommendations in place or positions on issues and policies until we hear from you. So the conversation today will be balanced. There isn't a one side for, one side against this morning. We don't want to run it that way. Plus, the marketing and advertising takes care of the polarization all by itself. You know where those two ends are. It's the conversations in the middle where the energy needs to be and where the opportunity lies about better understanding. So Ken, Selma, thank you for being here. I would say before Selma comes up and Ken makes a couple comments that the slides you saw from the previous speaker and you're going to see today will be put on the website of the Policy Forum, so you have access to them, download them, print them, study them, look through them. There's a lot of material here. We don't expect you to absorb it all, but we need to get a foundation established so we can have a conversation around all the issues. So with that, Selma, why don't you come up? And Ken, I know you want to make a couple comments.
Yeah, just, well, first of all, thank you for having us this morning. Thank you, Jim. How we'd like to proceed with this session is we do have a kind of a PowerPoint that Selma's going to run through. There are some places where I'm going to try to emphasize some things. I will try to resist the temptation to do it continuously, and I'll probably fail at that.
We'll help you with that.
Yeah, thanks. And then, we're going to, you know, our commitment to you and to Jim is to run through this quickly so there's time for, and I say Jim is sort of the Rick Albin of this session, for him to ask us some questions. Now, let me just say one more thing. We're in the middle of this presentation are some slides on the current ballot initiatives. We're going to kind of gloss over those quickly, the pros and cons, they're in here. I'm going to rely on Jim. If he wants to draw us out, he can do that at the end. And we do that because we think there's a bigger issue here at stake. There's an immediacy to these three ballot initiatives, but there's a process issue that we think is more important. And my ulterior motive is that the West Michigan Policy Forum, given your history of boldness and uniqueness, that you'd be willing to take on this issue in the future. So with that, Selma, please.
Great, thank you, Ken. Ken and Jim both have their work cut out for them. Ken's going to try not to talk too much, and Jim is going to make sure that he's playing Rick Albin as best he can. And my job is going to be to get a little bit of information into this conversation because we know it's generated a lot of interest both in this room and across the state. So why don't we jump into it? Early. All right, so as long as there have been ballot questions, there have been lots and lots of interest generated on how those ballot questions and proposals make their way to the ballot, how they're administered, how they're executed, what are the processes for quality assurance and making sure that we're not running into constitutional issues or other issues of process and execution. So we're going to look into this, and what we've found is that there really are 24 states where initiatives and referenda are allowed on the ballot, and each and every single one of them have a unique system of laws and processes to do this. So all of them are going to have to pave their own way. Michigan has to pave their own way, and we're going to start by talking a little bit of the history. But what you can expect from today's presentation is that we will talk about the history of ballot initiatives and proposals. We will also talk about the types of questions on the Michigan ballot. It's relatively Byzantine. You have to stick with me on that section. Ballot questions and statistics, so we'll sort of take a look at where Michigan is in relation to other states. The question of the 2018 ballot itself, what's on there. We will look at Michigan and comparing it to other states, and we will give you some key takeaways from our research. History of ballot questions. So, this conversation started when states were ratifying their constitutions in the late 1700s. Massachusetts was the first to approve its constitution through a ballot initiative. And then after that, a few decades later, New Hampshire, Connecticut, New York, and Rhode Island all followed Massachusetts' lead. In 1830, it gained a lot of steam when former President James Madison became a champion for this process. He wanted his state and other states to use the ballot process to ratify state constitutions so that they could be admitted into the Union. In the next 4 years, Alabama, Mississippi, Georgia, North Carolina all followed Virginia's lead and ratified their constitution via this process. Now, fast forward to the 1880s and the early 1900s, politicians in the progressive era really wanted to upend the way that the political establishment was making laws in their respective states. And they saw ballot initiatives as a great way to do that. So they became a champion for this process and wanted to turn over the process for making some laws, turn some of that power over to the working man, because they thought that politicians were a little too close to utilities. They thought the politicians were a little too close to banks and railroads at the time. South Dakota was the first state to add initiatives and referendum provisions to its constitution, and that was in 1898. Michigan followed in 1908, and we were a part of a wave. There were 10 states that did it around that time. After that initial surge of early Midwestern states and then later in the Western states, referendum in this process were added to only 3 other states since then. Those states being Arkansas, Wyoming, and Illinois, Florida, there were 4 states. History of ballot questions in Michigan. In 1908, this is when we started. The threshold was set, by the way, at 20% in 1908. That's how many signatures you had to have in order to get a ballot question on the ballot. And basically, between 1908 and 1913, nothing happened. Folks tried, nothing got on the ballot. Everyone said, well, maybe this is a little too complicated. So in 1913, we did a reform. And in that reform, we lowered the barrier to entry. And for the most part, we have been working with the exact same rules since 1913. We fiddled with it since 1913 and 1963, but the fact of the matter is most of it is the same since 1913.
That's just probably my first key takeaway, is that the current system in Michigan, with the exception of a few judicially required tweaks, is over 100 years old. And no state has added this to their constitution in the last 50 years.
The type of questions that are on the ballot. So there are 4 unique types of questions that can go on the ballot, those being constitutional amendments, referendum, statutory initiatives, and constitutional convention. An overview of each of these. Constitutional amendments allows voters to decide whether a change should be made to the Michigan Constitution, and it can go on by 2 different ways, either legislature initiated or through citizens. Some examples for the legislature side are lowering the voting age from 21 to 18 and increasing the sales tax from 4 to 6% in 1994. And then citizens, in their divine wisdom, decided in 1978 that they wanted to return that drinking age back to 21, and they did so via the same process that the legislature initiated. And then creating term limits, everyone's favorite dinner conversation, was enacted in 1992 via this process. Next is referendum, which allows voters to decide whether a bill passed by the legislature should become law. One example of this is the initial defeat of the emergency manager law in 2012. You'll probably remember that. When legislatures pass a nonpartisan, non-appropriations bill with a referendum provision, it is placed on the ballot after the governor signs it. Legislature passes it, governor signs it, it can go to the ballot, and constituents have an opportunity to say yes or no to that particular provision. Citizens can also call for a referendum on any non-appropriation bill, that's an important caveat, on any non-appropriation bill which suspends, and once they do that, it suspends the bill's inaction and execution until the voters have made a final decision. Note that there is a 5% threshold. That's how many signatures you have to have in order to get this one on the ballot. I'm going to go back and I'm going to tell you, constitutional amendments, by the way, are 10%. This is a bit of Swiss cheese. Every single element has a different marker for what it takes in order to get that issue on the particular ballot. 10% for constitutional amendments, 5% for referendum, and the next is statutory initiatives. Statutory initiatives allow voters to propose and enact legislation that cannot be vetoed by the governor and can only be amended or repealed by 3/4 vote from the legislature. This is initiated by citizens. You'll know the bottle bill is an example of this particular kind, and medical marijuana legislation was also championed through this method. I should tell you that several states allow initiatives to be sent directly to the ballot, and what that means is if a citizen or a group decides they want to exercise this option to get a ballot question on the ballot, several states, Michigan only allows the indirect option. What does the indirect option mean? That means that the legislature can adopt this particular proposal before it goes to the citizen. So happens, we collect the signatures, the Board of Canvassers and Bureau of Elections says we're good to go. After that is approved, the legislature can step in and say we're either going to adopt this or we're going to let it go to the ballot, which in this conversation we'll talk about several of those. There are a lot that are in this category in this particular election cycle.
And this is where I just feel absolutely compelled to just tell you what my personal opinion is. This 3/4 vote requirement for to amend a statutory initiative initiated by the people is probably, in Ken Sikkema's humble opinion, the single worst provision in all of this, because it's virtually impossible then to amend the statute. I mean, the bottle bill, which Selma mentioned as an example, you know, universally popular back in 1976 when it passed, still universally popular, but it's also, over time, has become the single biggest impediment for Michigan to do an adequate job of recycling. And we're going to see that time after time after time. My apologies, Selma.
No, you're right. You're not talking too much yet, Ken. You're doing all right. The last section, the last option is for a constitutional convention, which allows voters to decide if a constitutional, this one's pretty easy, allows voters to decide if a constitutional convention should be called. It's required, the Constitution requires that we ask this question every 16 years. And the question is, shall a convention of elected delegates be convened to draft a general revision of the state constitution for presentation to the state's voters for their approval or rejection? The last time this question was successful was in 1962, which led to a revised constitution and ratified in 1963 by voters. Support for the question has risen each time it's been asked, but we haven't crossed 33% since 1978. So we're pretty far off, unless there's a lot of work that we're going to do on the PR side. Ballot questions and statistics. So this one, this slide, I like. It's a little bit complicated, but you'll see in the middle part of the 1900s, so you got 1968, 1978, a lot of ballot questions, bedsheet ballots as they would call it. And then we sort of calmed down a little bit once we get into the 90s, and we've stayed about the same since the 90s. 2018, you see, is only 3. There's only 3 that are listed there in 2018. It would have otherwise been 6. This would have been a very, very, very large ballot this year had we not had some intervention from the legislature, and we'll talk about that.
I'm glad Selma's lingering on this slide a little bit, because if you like voting on these, you need to move and register to vote in California. The highest number we've had since the '63 Constitution was 10 in 1978. California has an average of 18 every election. So if you like doing that, register to vote in California.
And then success. So when we do get it on, when we do have a ballot initiative, there's an over-under. Some do well, some don't do well. The best outcome, the folks who are most successful, are when there is a voter-initiated referendum. Voters are very, very good at telling you when they do not like a law, as you might imagine. And 9 times out of 10, they're going to do that and they're going to be successful. The next is constitutional amendment by the legislature. So that last one looks like it's cut off. It's the 50% mark there. It's about 50-50 whether or not the legislature can get a constitutional amendment through, and statutory initiative you see there is 54%. 3 statutory initiatives no longer on the ballot. So now we're at present day. You have the minimum wage rule, you have paid sick leave and prevailing wage. You probably all know what these are, so I'm not going to belabor the point. Minimum wage increases minimum wage and creates tipped wage parity over several years and adds overtime rules as well. Paid sick leave requires businesses to allow workers to accrue paid sick time. Prevailing wage, which repealed state law requiring prevailing wages and fringe benefits set by the state for workers on state projects. Here's what we should know. Proponents of the prevailing wage, and I think a lot of them are in this room, proponents of the prevailing wage rule wanted the legislature to adopt this, which means that it did not go before voters. Now, if it had gone before voters and passed, the same rule that Ken was just talking about with the bottle bill would have applied to this particular rule. So the three quarters rule does not apply to the prevailing wage rule that was just passed by the legislature because they passed it themselves. The other thing that you should note that I think is really interesting is that only 6 times since 1963 has the legislature done this, where they have taken a proposal that was headed to the ballot. They stepped in, they have a constitutional authority to do that. They stepped in and said, we're going to accept this ballot proposal and we're going to make it law. That's happened 6 times until today. That has happened 3 times, so we're up to 9 because of these particular initiatives. The legislature has stepped in and said, we're going to adopt these. The other note that I want to pause on is that the legislature has never amended, in the 6 times prior, the legislature has never amended one of these ballot proposals, one of these initiatives, in lame duck session. It's not happened. There's a lot of rancor around, if you do this, then I'll sue you, and that seems to be the biggest, one of the biggest takeaways I can tell is that there are a lot of lawyers making money on this, this particular issue is really, really hot, and we are in an unusual year, just based on the fact that 3 of these were adopted by the legislature this year. Voters, not politicians. You guys probably already know this really well, so we're going to talk about the ones that are headed to the ballot and voters will have a say on. This one's designed to reduce potential for partisan gerrymandering. That's what the people on the pro side say. On the con, they say that it shifts power from the legislature to the Secretary of State, who will essentially be overseeing the commission's work. You probably know the details, so we're not going to go into the nitty-gritty because we'll have plenty of time to talk about that later. But the next one is promote the vote, which makes it easier for residents to register to vote. That's what they say it does. And then the folks who are against it say that it increases an administrative and logistics burden for the Secretary of State. And the next one I think is worth noting on this slide, which is that several policies already exist or are covered by state and federal law that this issue seeks to deal with. So we're saying that this particular provision is saying that we're going to do things that frankly are already covered in existing law. Marijuana legalization. This one, proponents believe that it will result in significant cost savings from reduced arrests for marijuana possession, and folks who are against it believe that it's a gateway drug and you shouldn't do it. Since we just had a bunch of conversation about roads and bridges, it is also important to note that this particular one creates an excise tax of 10% for local governments' K-12 education and road and bridge maintenance. Funding ballot questions. So I know there's a lot of interest on where the money comes for these, so we did look at this, and the latest data goes up until July of this year. The minimum wage increase, $1.4 million as of July, had been raised, and 62% of that came from money outside of the state. Paid sick leave, $2.5 million was raised, 98% came from outside of the state. Prevailing wage, $1.5 million was raised, and 1% of the money was raised from outside of the state. The initiatives that are actually on the ballot, voters, not politicians, $1.5 million, 22% outside the state. Promote the vote, $2.7 million, 88% outside the state. Marijuana legalization, $1 million, 76% outside the state.
So very, very quickly, kind of Ken Sikkema's editorial comment. Of these 6 proposals, 2 of them, if you just look at the funding, where the money's coming from, and I don't want to get too self-righteous about money in politics because it's there, but if you just look at where the money is coming from, 2 of these proposals are basically homegrown to Michigan. The prevailing wage repeal and the redistricting proposal. The other 4, paid sick leave, minimum wage, promote the vote, and the marijuana decriminalization, those 4, they basically are not homegrown proposals. No pun intended about marijuana.
Legislatively initiated constitutional amendments. This slide just talks about the percentage that you need in order to change or amend or accept a particular proposal as it relates to constitutional amendments. It is worth noting that every state in the union allows the legislature to place a measure on the ballot as a constitutional amendment except Delaware. All of those states require a popular vote to approve constitutional amendments. States that allow voter-initiated ballot initiatives. Michigan is the only one of 15 states to allow for the full gamut of citizens-initiated questions. So you saw the 4 questions that we had up there: constitutional amendment, statutory, referendum, all 4 of these. Michigan's the only one that does that out of the 15 states. We allow our citizens to do all 4, so that is unique. 24 states don't allow for any type at all. Citizens can't get to the ballot whatsoever. 24 states don't allow citizens to do it at all. So when you compare Michigan to other states, the constitutional amendment, Michigan is, there are 2 states, so this is actually research from the Citizens Research Council, and they did a really, really good job here. The constitutional amendment, there are 2 states that make it easier to bring a constitutional amendment to the ballot. There are 2 states as it relates to referendum that are easier. And for statutory initiative, we're somewhere in the middle. There are 9 states that make it easier. That means everyone else is to the right of us. In most cases, we are somewhere in the middle. Michigan is about average as it relates to statutory initiatives, but most states are more strict and have a much harder barrier to entry as it relates to voter-initiated referendum and constitutional amendments.
And this slide, of the whole deck, if I could burn this slide into your memory, I would do it. Because from left to right, left being easy, far right being difficult, all 50 states, you see that little Michigan symbol. You know, Michigan is relatively easy, particularly when you remember that half the states don't even allow the voters to initiate laws or constitutional amendments. It's relatively easy to get on the ballot in Michigan.
Factors impacting the degree of difficulty. So Ken was just talking about how easy it is to get on the ballot in Michigan. Here are the things that we or policymakers can tinker with if they want to adjust the level of difficulty as it relates to getting on the ballot. The first is support in multiple sessions. So some states, and this would include Nebraska and New York, have required potential constitutional amendments proposed by the legislature to receive majority support in multiple consecutive sessions to be placed on the ballot. That means the legislature that comes up in the legislature that's sworn in 2019, and then the next one, and then the next one would have to approve a particular constitutional amendment before it can be placed on the ballot. So the legislature can make it harder for themselves. An indirect versus a direct process. So the question here is there a legislative component? Do we allow or require the legislature to intervene or to have a say in a ballot initiative before it goes on the ballot? And a constitutional amendment in Michigan, no. The legislature can't say a thing about it. But statutory initiative, the answer is yes. The legislature can do something, and they did exercise that right this year. Petition and signature rules. This one is really, really hot. And under this category, you can play with the number of signatures, you can play with geographic diversity, you can also play with the collection window. An important note about the collection window, which is that it's not dispositive. There are plenty of states that have shorter collection windows that have more ballot questions than we do, and there are plenty of states that have longer collection windows that have less ballot questions than we do. You can also talk about the circulator's age, their registration status, identification, and compensation rules. The next one is pre-screening and substance reviews. So many states work to ensure that petitions aren't misleading, that forms are in proper order, and that the petitions are constitutional. Now, this is sort of a quality check is the way that I look at this particular provision. And in that quality check, what ends up happening, if you don't have it, there have been states that have had some pretty heinous things that have happened once voters go to the ballot. You've had typos. You've also had errors in which statute a voter is actually revising. So they've had some real messes on their hands when we don't have a quality check. And in Michigan, we do not have a quality check. Subject matter restrictions, so the actual, what you can talk about, and slightly more than half of the states allow voter-initiated ballot questions. Those states limit the range of issues that can be asked at the ballot. And the last one is fiscal impact statements. Some states do require that that we develop a fiscal impact statement so that voters have an understanding of what financial matters are at play by voting yes or no on this particular initiative. Petition and signature rules, the number of signatures. What I think is most interesting on this slide is that it's all over the map. Some states require as little as 3% to get on the ballot, and some states require as much as 15, those states being Massachusetts and Oklahoma, respectively, as examples. Petition and signature rules, geographic diversity. There's a lot of states that do this. 50% of the states that allow voter-initiated ballot questions, not including Michigan, have some form of geographic diversity. Ohio, Montana, Florida, Missouri all do this. Pre-screening requirements, this is the quality check that I was just talking about. There are several states that do this, and it's worth noting that Oregon and Colorado have very high rates of ballot questions, but still have some form of pre-screening. So it is clear that you could put a pre-screening requirement in the process, but it doesn't necessarily mean that it's going to make it particularly difficult for them to get to the ballot, as Oregon and Colorado have demonstrated. Key takeaways. So, what I think you should learn from this is that every state is different. Every state does this. They have their own flavor to it. And in a lot of ways, that makes it somewhat difficult to sort of pinpoint who's easier, who's harder. We've tried to do our best with that. But what I think is most interesting is really it's an exercise in federalism. Every state is going to do their process differently, and they have the autonomy to charge their own path. Next, just over half of states allow voters to do this at all. And so there's a full range. You can make it really easy for ballot initiatives, or you can shut the door entirely and say, we're not going to allow this in our state. Key takeaways is that we've been playing on the margins for a long time. Ken mentioned that we haven't had significant revisions outside, frankly, of judges who have tweaked on the margins. I know that there's an attorney general that's running right now and have said, we're not doing this rule at all, or we're going to change how this is enacted. But as far as policy is concerned, we really haven't touched this thing since 1913 in any meaningful way. And the next you should take away is that if you want to get on the ballot, you got a 50-50 shot. You want to get on, you've got a 50-50 chance of whether or not your proposal is going to win the day. Legislative constitutional amendments are more likely to succeed than voter-initiated ones. And while it doesn't happen often, apparently voter-initiated referenda are the most successful ballot questions. Lastly, if successful, these ballot proposals are near untouchable by the legislature. That is as it relates to statutory initiatives. So if those are passed at the ballot box, what Ken just said, you have to have a 3/4 majority in order to get that thing amended. That's the case with the bottle bill. That basically makes it bulletproof. You can't touch it. And statutory initiative, Michigan is about average in terms of difficulty and how we get on the ballot. And constitutional amendment, most states have a higher barrier to entry. So most states are harder to make constitutional amendments, and we're somewhere in the middle as it relates to statutory initiatives as far as access is concerned. And last, geographic diversity for signatures is a really hot topic. That's something that you can play with. And then the last question on constitutionality and pre-screening, Michigan does not currently do this. And we're sort of in a cross your fingers and hope and pray that it works situation with our policy in the state. And just in summary, if you could put the things that you can do into buckets, they would be access. Can you make it easier or harder to get onto the ballot? And then there's a process question. So shifting the process from a back-loaded process to a front-loaded process. Right now we're back-loaded, which means that you can get on the ballot, you can collect your signatures, go to the Bureau of Election and the Board of Canvassers, they approve you, and basically after that it's a free-for-all in the courts because it's all suits, it's all tort after that. And then the last is whether or not we can make it easier for voters to understand what's actually on the ballot. CRC did some research on this. Michigan currently does not do this. There are other states that require the Secretary of State to put out policy briefings and information so that voters actually know what they're voting on, and the state plays a role in that. That's it. Ken, you get to talk now.
Helmut, thank you. Let me, let me transition talking about a little bit more specificity. I told you that you probably didn't have a full grasp of all the things that go into initiatives, particularly when they can become a law we all live by. And the process by which that's created, we become comfortable with by electing people to represent us, holding them accountable, and unelecting them if we don't like it. It's pretty straightforward in that regard. And we have a full-time legislature that's designed to do those things. So why do we need these? We're going to get into that in a minute. More importantly to me is how they get there. Someone did a great job of going through the myriad of opportunities and options there, but let me ask Ken, when someone wants to get a ballot initiative on, and there is now a fairly low threshold for signatures, tell me what requirements they have other than just get the number of signatures they need when they get to the Board of Canvassers or others to get that on the ballot if it is unknown to or not involved with other parts of the state.
Well, there's two things I would do right now if I wanted to get something on the ballot is, first of all, I'd hire a good lawyer, and I'd hire a good fundraiser, because that's how you get there, generally speaking. There are exceptions. You don't have any kind of geographical diversity requirement in terms of the signatures, as opposed to if you're running for governor, you actually do have to gather some signatures from a number of counties in Michigan. Is that the question you were asking,
That's exactly
Jen?
the question. So when we elect someone, in 43 days, we sit down with Governor Schuette and have a conversation with him about the things that hold him accountable for what he's doing. He would have had to go through a process to convince Michigan to put him on the ballot. It takes a very small geographic area and a very small number of signatures that put all of us on the responsibility of whether or not that becomes a law for us. Selma, react.
So this point is exactly right, which is that when these ballot initiatives happen, the access is relatively easy. What I think is most interesting is that the state initiative, the legislature can step in and say, we're going to adopt this, we're going to accept this, and we're going to adopt it and bring it in. We think it's a good idea, or maybe we think it's a bad idea, and we want to avoid the three-quarter threshold. But constitutional amendments, forget about it. If you want to amend the Constitution, you go straight to the ballot. The legislature can't say a thing about it. And if you were in the progressive era, if you were a politician in the progressive era politics, then in the late 1800s, this was what you wanted. You wanted the legislature to not have access to some direct democracy. And I think that's what a lot of this comes down to, is how much direct democracy do you want? And in Michigan, we're saying that we want a lot. Other states are saying we want very little.
Can I react to that? And because you brought this up right at the beginning, Jim. Yep. I consider myself a conservative. Now, we're in a day and age where, that's loaded, because if you aren't a conservative like me, you're not a conservative, right? But when I say I'm a conservative, it's sort of like the Merriam-Webster dictionary definition, sort of traditional institutions, reluctant to change. And I mention that because the fundamental philosophical, political issue at stake here is, I believe voters have one responsibility, and that is to elect office holders. And it's the office holders' responsibility to enact laws, and then it's the voters' responsibility to hold them accountable at the election. Frankly, I don't even think it's fair to ask the voters to make a complicated legislative question. This whole minimum wage thing is a good example. The legislature in the past has passed increases in the minimum wage. What's unique about this one is that it eliminates this tip credit. And I can say with a pretty good degree of certainty that there is no Democratic legislature or Republican legislature that would ever consider eliminating the tip credit. It's bad for waiters and waitresses, and it's bad for the restaurant owner. But that would be part of the ballot proposal. But voters aren't going to have the time or inclination, or frankly, they shouldn't have the responsibility to be wrestling with the nuances of these proposals. So I wanted to react to both what you and Selma said about my view is that voters have the responsibility to elect people and those people have the responsibility to pass laws.
It's exactly right, Ken, and it is what it is today. We want to make sure you're aware of and sensitized to and keenly in touch with how this can happen. Populism is obviously on the rise throughout the world and certainly in politics, and things can happen that we all have to live with if they get in a place where our legislatures are being sidetracked or circumvented. Some cases they need to be. If they're not doing their job during the time they're there, we can do things about it. But we live in a world where checks and balances matter to us. At least we believe that we have those in place. We wanted you to know, while we have the alternative, it's been 100 years since we've looked at whether or not it serves us well today, and will continue. So let's move on to the ballot initiatives we're working with today. Let's start with and articulate a little more about the alternatives that positions are taking with the voters, not politicians, the redistricting gerrymandering. Selma, would you pick that up and give us, if you will, a ground level look at why is this so hot? Why do you think it got where it is? And what exactly are people contesting about?
Sure. I think that a good place to start is why this is so hot, which is that gerrymandering, and I was somewhat surprised by this. I was a political science major, and I thought I was the only person who cared about gerrymandering. But apparently, citizens and residents do care about gerrymandering, because this really took a lot of people by surprise when this group, which got a lot of money from outside of the state, when this group was able to come into the state and really barnstorm signatures. Everyone was sort of taken aback by the signature threshold, how many they collected, and the swiftness and the speed and the volunteers, the fact they didn't pay people to do it. And the reason is because they've been able to generate some excitement about how the system works by which we put politicians into place. And their particular bend is that politicians shouldn't pick their voters, voters should pick their politicians. And this was as you all know, every 10 years, the state is required to redraw its district boundaries. And this was really hot. It's no secret that every political party wants to be in control, wants to be the one who's drawing those maps. And it's a question of how effective or how fair or unfair they are in drawing those maps to their own advantage. And this particular group saw fit to jump into that. One thing that's worth noting on this particular initiative is that these folks have really have sort of glommed on to the fact that that votes, it's sort of like the Electoral College. I think it's the exact same thing. People can get upset about the Electoral College, but that's the process. You have to get votes in every single state. There has to be a certain amount of diversity, and we've been living with that for a very, very long time. So these issues are parallel to me, and popular vote, it's really a question between popular vote and how much you need to get in the various parts of the state.
But Ken, is it not true that the way it's being proposed, just so the audience understands, that there will now be another entity that's created by which we're going to draw districts on what district we're in, and therefore who we get to vote for based upon their running. So how does that get created, and how do we hold those people accountable?
Okay, all right, Jim. What I need to do here is I need to take my PSC hat off, which is nonpartisan,
You can give it to me.
independent research firm, doesn't take position on issues, and put my Ken Sikkema hat on. And I'm biased because I participated in 2 redistricting plans in the state legislature, one in the House, one in the Senate. I am not a fan of this proposal for a couple of reasons. One is it has a very vague, undefined criteria that says once the commission is established, and it is sort of randomly selected. Once it's established, they may use the term is community of interest in drawing lines. I don't know what that means. I don't think anybody knows what that means, meaning you all have your own definition of what it will mean. That's disturbing to me. I think it's, the current law is very clear about not breaking municipal lines or keeping districts contiguous and compact. The language in this proposal keeps that language, but it makes it subservient to this community of interest definition. I don't like it. It's ill-defined. You put it in the Constitution, you can't get it out. which is why I'm not a fan, Jim.
Selma, this seems to be, as well as the community interest, which we don't know who's going to be on it, allowed to be on it, how they get put on, how we get them off. There's also who's allowed to be included in the process, some restrictions around that that go way past what would be natural and normal. React to that a second.
Sure. So I believe it's 4 Democrats, 4 Republicans, and
That always works.
maybe 5 independents or a third party, and you have to have two in each of those categories have to approve the maps. So that means that you're going to have a group of people that are going to have to self-identify as being a Democrat or a Republican. I don't know. I mean, you could have some chicanery with that, and someone could say, I'm a Republican and I'm really a Democrat, and vice versa. But these are issues that they're going to be somewhat untidy. They're going to be somewhat messy. To me, they're pretty similar to how they got on the ballot to begin with. We don't have a pre-screening requirement on the state. We don't have a pre-screening requirement to talk about the constitutionality or whether or not this is going to run into any other statutory issues if this thing gets passed.
Does Michigan require party identification in other categories?
That's a good question.
I don't believe you'll find it does pervasively.
No.
And in this case, you got to declare who you are on the record, and they assume you will act accordingly to get on the commission.
Yeah, Selma's right that this commission has to be 4 Dems, 4 Republicans, 5 independents. But the issue is, okay, who's a Republican? You basically have to swear, Dutch Christian Reform, I can't use the word. You have to have an affidavit, affirm that you're a Republican. There's no sort of official credential, I guess, that you'd have to offer. So, I guess, there's potential of chicanery in that. To me, a bigger issue is the fact there's a lot of people excluded from serving. So, in other words, in the last 6 years, if you are elected official, partisan official, registered lobbyist, you can't serve on this commission. Okay, well, maybe that makes sense, but your spouse can't serve. Your mother can't serve. Your father can't serve. So some poor soul who takes up, honestly, this mantra that we say we want you to get involved in politics and runs for precinct delegate, they can't serve and their mother can't serve. Seems a little, undemocratic to Ken, but.
So there's the challenge. And again, we're providing the information without taking pro or con. You got those in your decks, but there's an awareness that says, did we pass the do no harm test before we put this in place, or will that be the case if it's adopted? So let's move on to promote the vote. Who could be against that? So let's chat a little bit about the energy around that. Selma, I like the way you frame these things, so Ken gets a chance to push you back. So tell us a little bit about the energy around this and the criteria around why they're looking to have something change and what you think the consequences will be if it happens, and then Ken react accordingly.
So the big one on promote the vote is really about same-day registration and being able to register all the way up until the day of election. This is something, and no reason absentee. So those are probably the 2 hottest pieces in this provision. Everything else is pretty well covered in state statute. There's a lot of talk about the service members who are serving overseas, them getting ballots. Well, we already do that, and that's what a lot of the cons say. A lot of the folks who are against this particular initiative say you're already talking about things that we already cover. And this one is particularly ugly in that when you look at all the places that it's seeking to amend, it's pretty Swiss cheese. You can't tell where it stops and where it begins, but it has generated a lot of excitement, and I think in particular because people want no reason absentee. They want it to be easier. If you're a business person, there's a lot of folks in this room, that's a sexy headline, and that's why they've gotten some traction, is because they found a policy that can cut through, whether you're Democrat or Republican, the idea of making it easier to vote. Some people are excited about that. That doesn't mean that it doesn't come with a whole host of challenges and or problems for our democracy.
So Ken, let me ask you to react to that, as well as bring in the concept of straight ticket voting, so we can get into that a bit for the group.
Yeah, Selma's right. There's actually, he mentioned 2. There's 3 big pieces. Same-day registration, no reason absentee voting. Right now, you have to be over 60 or out of town. And then it constitutionally would allow for straight ticket ballots. This is my issue with this kind of proposal. You could very, very easily support 1 or 2 of those big ticket items, but oppose the third. For example, the Republican Lieutenant Governor candidate, Lisa Posthumous Lyons was here today. In her legislative career, she championed the idea of no reason absentee voting. But I'm pretty sure, like me, she's opposed to same-day registration, and she would like to ban straight ticket voting. But you know, you are now compelled to cast a vote, and you can't discriminate. You can't vote 3 different ways on a proposal like this. And I think there's a lot of people, if they really knew this proposal, dissected it, looked at these 3 issues, I think it just stands to reason that there'd be a lot of people that say, well, I support that one, I oppose that one. But you're forced now into casting one ballot for 3 pretty, you know, substantive issues on their own. The other states, there are states that have same-day registration, for example. It's not a foreign concept, but they all do it statutorily. So if you run into problems, they can change it statutorily. This is a constitutional amendment, people. You're not going to be able to change this if it gets in there.
So, Selma, the examples that I think you showed about the 3 that are not on the ballot came about where our elected officials stepped in and said, wait, that's not necessary. We have an opinion. We think we know what the voters want us to do. So we're going to do what we believe is the right thing and get the consequences of that. Why not here?
These particular 3, it's highly unusual, right, that the legislature would step in and say, we're going to do this. It's only happened 6 other times since 1963. So I think that gives you, that should give you a sense of just sort of how unusual or different this particular year is. And what's also worth noting is that the 3 initiatives that are there, in particular the prevailing wage, if they had gone to ballot, that meant that they would have had a 3/4, which is what Kim was just talking about, the legislature would have had to have mustered 3/4 of the legislature in order to pass these things or to change them. Bulletproof. You're not going to get that. But the same is true, the corollary is also true for the prevailing wage. If you're a really big proponent of the prevailing wage, well, the next legislature, because we've accepted it in this particular, in this venue, that means that the next legislature can change that as well. So I think we can mess around with the margins, we can change a lot, but what's good for the goose is good for the gander, and not everyone is always in power so these things are going to volley back and forth.
Excellent. So I'll calm you guys down, mellow out a little bit, and talk about marijuana for a second. When I was growing up, there was a movie out called Reefer Madness, and nobody would touch that stuff. You drove crazy, and away you went. Didn't even know who you were afterwards. It's obviously come a long way in the public conversation, and several states have chosen to move forward. And we do have some history, and we've got some reflection from that period of time to look at. So I'm going to start the same way again, and can ask you to react a bit. This has a lot of energy, a lot of money coming in around where it's getting on the ballots and not. So react a little bit to the foundational beliefs around why it's come up now, and certainly some points of view and opinion you have around it. And Selma, you're going to get the same chance to react to Ken this time.
Well, I feel a little bit like Kenny One Note here. I don't like this proposal. In Selma's presentation, one of the examples he used of a voter-initiated statute, which is what this is, was the 2008 approval of marijuana for medicinal purposes. And it has been chaos since then for 10 years, 10 long years, in terms of how to regulate it, because it takes that terrible 75% vote from the legislature to amend it, which is virtually impossible. And I will just say for the record, with all due respect to the people who sort of use the alcohol, prohibition didn't work argument, it doesn't make any sense to me to legalize another substance that causes impairment, driving at school, at work, and the implications of that. I have yet to be able to cross that threshold mentally for me to be able to support something like this. But once again, I still feel that 3/4 vote can rear its ugly head on something like this.
Selma?
Onerous, at 3/4, it's onerous, right? It's going to be nearly impossible to do anything with it. And Ken sizes up the issue really well. If someone is partaking in this particular form of recreation, if this passes, they're going to be able to do it ad infinitum. The legislature is going to have a really, really hard time amending this if for some reason we need to change the rules in Michigan.
There are some practical applications as you look into this legislation, should it become law. You've got traffic stops. There's no on-site testing, DUI, DWI type of situation, so you've got that. You've got at work colleagues and employees coming in, no way to know whether or not they're either under the influence or not. So there's some real challenges about making sure that the people that have to make this part of their lifestyle for safety and the safety of all of us are challenged with. But I wanted you to hear, regardless of how you come down politically or socially on this, that if these get through, in the form they are in today, the ability for the people that we send to help set laws and regulations in place for us will have almost impossible consequences or thresholds to deal with to make any changes to this whatsoever. So it's timely that we had the conversation. It's why we do what we do at the forum. There's a lot to think about here, and this process ultimately, we believe, needs to be looked at in some way, shape, or form. And we believe also there was probably a benefit for looking at the process before we know the outcomes that are forcing us to look at the process. But somehow that's how it works, and we have to make it worthwhile. Closing comments from each one of you. Selma?
This is going to be a sticky wicket. The voters are making their voices heard, maybe in ways that they don't fully understand or recognize. And no matter how this whole thing turns out, we have a process and a system in place. And if we change that process or that system, it is going to be accessible for everybody. So tweaking it, it's going to volley back and forth. And this is a space where you have to ask yourself, how much direct democracy do you want? Do you want a lot of direct democracy in Michigan, or do you think that is more up to the legislature and we want our citizens to be able to stay at arm's length as it relates to this issue?
Ken, you have the last word.
Well, these three entities, constitutional amendment, or voter-initiated constitutional amendment, statutory law, referendum, are embedded in the Constitution. They're not coming out, but it's my hope that some changes could be made to affect the process and return as much as we can to what I think the original concept of what a representative democracy is. And it's my hope that the West Michigan Policy Forum takes us on in the future.
Hope this was helpful, folks. Thank you, Ken, Selma. Nice job.